Hi, I'm Loren Locke. I'm talking about the EB1A and the high pay category criterion for showing your extraordinary ability by showing that you have earned a high remuneration compared to other people in your field. When I'm first analyzing whether this one's going to be possible for a client, I look to the OFLC wage data, which is the same thing that you would do for an H-1B. If you are an H-1B worker, you can look at your LCA and you can see what occupation your job is classified in. That's how you're going to know that you're looking at relevant information for you. So I'm a lawyer. I'm in Atlanta. I'm on the OFLC wage search, which is run by the Department of Labor. I put in my occupation, which is coded as 23-1011. I have selected my county. I go in and it shows me for my metropolitan area a level 1, entry level, 2, 3, and 4 wage for my occupation. I also see the mean wage for my occupation. So I see that level 4 wage in this case is about $272,000. If I were trying to use this and show that I am highly paid for my EB1, then I would want to have a history of earning comfortably above the level 4. Now, there's no dollar amount that USCIS is going to go by to say, oh, well, if you have 300, you surely win. It depends on your metropolitan area and your occupation. You want to be way above the mean and you want to be above level 4. Now, if you have an executive compensation summary or an expected earnings or whatever, the paperwork that shows your stock options, something like that, that's a huge positive. But sometimes USCIS will turn around and say, well, because of those stock options, or because of your bonus structure, you earned way more than the mean or the level 4 wage, but maybe those wages weren't based on with stock options. I have seen some arbitrariness about if they'll discount. I have seen cases, not in the really recent past, but in past years where they could look at somebody's salary that's really high and still say, well, it's not necessarily high enough. And the other thing that I see more commonly now is that they say, well, you've used the wrong set of data. It's the wrong occupation. They get confused between job title and occupation. So they'll say, well, you said what lawyers earn, but you didn't say what partners earn. Because guess what? Partner is not an occupation. There is no wage data for partner. Partner doesn't say what industry you're in. Partner is a title that lots of different companies use and they mean different things by it. So it is unfortunately not uncommon that USCIS will nitpick you like that and you get a request for evidence and you'll have to re-argue the point about, no, partner in this case means lawyer. Lawyer is this occupation. Let me show you the ONET. Let me show you that partner is an acceptable job title for lawyer, and you're explaining stuff that seems very obvious to you in your field. But remember, your field, your occupation. Your adjudicator doesn't have that subject matter expertise, that familiarity, that idea of what's a normal career progression in your company or in your field. So it's really our job to lay it out for them in a simple, digestible way that makes it clear that, wow, you're earning a lot of money compared to other people doing the same work that you do.